Barring one, my lord, all other issues are covered. My lord, I have lost the other litigation. Therefore, all other contentions except one, my lord.
My only submission is, my lord, principle of res judicata applies because very same notification, if it is raised,
Yes.
not raised,
Constructive res judicata.
constructive res judicata.
Therefore, my lord, I submit on all, I have raised several contentions, my lord. On all contentions, barring one contention, my lord, the only contention, my lord, that I can possibly argue before your lordships is, my lord, that page 210, my lord. Let's recruitment to various posts. Let's page 210, my lord. Your lordships have to. Yes. I'll just explain what there were two posts, my lord, amongst others. Chemical supervisor and chemist, my lord. Chemical supervisor required BSc, chemist required MSc, my lord. Now, while writing the examination, we realized chemical supervisors were given MSc standard question papers and chemists were given BSc, my lord. It has interchanged. Now, how do I demonstrate page 210, my lord? The same person, Somshekara B, who has written chemist, secures 77, while the lower post he secures 36 marks. Page 210.
No, the challenge is to the notification.
But challenge is, I have challenged the entire thing, my lords. I am essentially today confining only insofar as the exam, the question paper that were given to us. We had applied for the post of chemical supervisor, my lords.
How do we get into all this?
Yes, my lord. My only
question paper tagondo.
Yes.
And as an expert, decide whether
your lordships can't do it, my lords. I can't request your lordships to see the question, get into the technique. My only request is, could it be referred to an expert who can give your lordships, my lord, the report, and then that's the end of the matter. Whatever is the report, I'll have to stand by.
No, this notification,
yes,
is calling for examination. Examination is conducted.
Yes, ma'am. It was cancelled 4 times, my lords.
Correct.
5th attempt was failed, my lords, in the judgment that I have just passed on, my lord.
So you applied to the post of a
chemical supervisor.
You were given tough questions.
Yes, my lord.
So
how do I, my lords, demonstrate prima facie, even to request your lordship to send it to an expert? I should be prima facie able to demonstrate, and that is at page 210, my lord.
Now, the challenge to this notification has been negated by this court.
Yes, negative.
Now, the challenge is to the question paper.
No, on 2 counts only.
Prayer for that. Prayer.
My lords, kindly have a look at the prayer.
Withdraw madi ನೀವು
petition. Kindly have a look at the prayer.
You have to ask, declare, and all further proceedings.
And all further proceedings, action taken. I am only insofar as the exam only.
Ground idea idralle.
My lords, exam ಬಗ್ಗೆ specific ground ತಗೊಂಡಿದೆ. Can I just show that? My lords, 5.4, my lords. I'm sorry, 5.4. Yes, page 31. Specific ground, my lords.
This reminds me of our law exams earlier. Everything is tough from first year to 5th year.
There is one other contention, my lords. Recruitment notification says exam should be in Kannada and English. My lords, but the question paper was only in English. I'll tell your lordships, my lords, what your lordships can hold against me. I have waited for the results to come out and then filed the writ petition. I should have challenged immediately after the exam.
December.
Nevertheless, my lords, exam was conducted only in one subject. My request, my lords, I am not even seeking to stall the proceedings today. If 210 I am able to demonstrate, persons who have written both exams have scored lesser in chemical supervisor, lower post, but have secured higher marks for the higher post.
So the cascading effect is
but this is the 4th examination which you held, and we are not filled up vacancy nearly for 7-8 years, Manoj.
But that might not be a ground to reject.
It's only the legality. Now you want the court to look at the question paper, refer it to an expert, and get a report from the expert that these are not of the standards of a BSc.
We were given
MSc higher standard.
Yes.
And therefore, because of that, you didn't do well in the examination.
Yes, ma'am.
And you failed.
Yes.
And passed the examination and asked for a re-examination.
Yes, ma'am. May I request this, Malad?
It is too much.
No, Malad. I'm only saying this, Malad. For 3 times, Malad, we have qualified. 3 times when in the last round of litigation, Malad, final list, our names were found. Thereafter, it was cancelled.
See, it's better.
Yes.
You withdraw this, file a proper writ petition referring to this, and say that this ground was not addressed. Therefore, there is no.
In fact, that is why this was kept separate from that batch of writ petitions. I had made a submission because only insofar as this, your lordships, any date consider this, I'll try and place some judgment, to persuade your lordships. I'm not requesting your lordships to consider the question papers. If your lordships can be satisfied by an opinion of the expert, not necessarily my expert, I'm not even suggesting. Even somebody from Bangalore,
What will happen is, this will have, if a question paper is attacked on the ground that the standards in the question paper much higher than what was to be, what is prescribed, then every education matter, everything people can go on saying.
But the distinction would be this, there's a fixed syllabus for education matters, for unlike this, we were only told BSc of university level, I can only
too broad, I don't think that exercise in 226, I don't know whether it's been done earlier.
No, Malad, and one other thing, the implication of this is, Malad, setting aside the whole thing,
implication, in fact, was specifically rejected in the last round. They said it doesn't matter if the entire recruitment, division bench judgment, please have a look at it.
That is if the notification held to be invalid.
No, only the examination was called in question.
Correct. And the examination was quashed, is it?
Examination itself, it was till the stage of final exam. Up till the stage of final selection. At that stage, the writ appellate court said it doesn't matter what the consequences.
Why does it set aside?
On the question of negative marking, at the time of examination, negative marking was lately introduced.
With the lordships, kindly, court officer, the same proposition what my learned friend is urging, has been considered with page number 76.
That's what exactly. Discrepancies in inconsistencies in question papers. It's all well settled, right? We can't get into that area at all.
Give one copy. Sorry.
Yeah, no.
Para 16, it says the Hindustan so has held that in case of
Agala.
Your lordships can't do it, I'm straight away. Your lordships can't bring, sir. This was the case. It
becomes a bad precedent.
Can I just...
After I said, because in every case, this thing of referring it to can't happen.
Can I persuade you? In these cases...
ಸಮಾಧಾನಕ್ಕೆ ಅಡ್ಜನ್ ಮಾಡ್ತೀನಿ ಸುಮ್ಮನೆ ಪೆಂಡಿಂಗ್ ಇರೋಣ ಅಷ್ಟೇ ಅದು ಏನ್ ಮಾಡೋದು
ಹಾಗಾದ್ರೆ ನೆಕ್ಸ್ಟ್ ಮಂಡೇಗೆ ಹಾಕೊಳ್ಳಿ ಐ ಸಿ ಇಫ್ ಐ ಆಮ್ ಏಬಲ್ ಟು ಪರ್ಸ್ಯೂಡ್ ಇಫ್ ದೇರ್ ಎನಿ ಅದರ್ವೈಸ್ ಐ
ಏಪ್ರಿಲ್ ಫಸ್ಟ್ ವೀಕ್ ಒಂದು ಡೇಟ್ ಕೊಡಿ
ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ಮಂಡೇಗೆ ಕ್ಲೋಸ್ ಆಗಿ ಮಾಡ್ಬಿಡ್ಬೋದು ಇಫ್ ದೇರ್ ಇಸ್ ನಥಿಂಗ್ ಮಲಡ್ ಐ ವಿಲ್ ಓನ್ಲಿ ಅಡ್ಮಿಟ್ ಮಲಡ್ ಇಫ್ ಐ ಆಮ್ ಏಬಲ್ ಟು ಫೈಂಡ್ ಸಮಥಿಂಗ್
23rd 16th
ಮಾಡ್ಬೇಕಾದ್ರೆ ಅದನ್ನು ಡಿಫೈನ್
ಸಕ್ಸಸ್ಫುಲ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಇದೆ
ನಾವು
ಯು ವಾಂಟೆಡ್ ಟು ಬಿ ಸೆಟ್ ಅಸೈಡ್
yes
wait and watch
anyway court is adjourning let's see
16th
please wait
34 and
34 other than self I'm still because what will happen is this process of interpreting somebody, see if the judge is retired or transferred is different thing. He's very much available.
I agree on principle, Malad, it can't. 4 times it is cancelled. Somebody has to at some stage get appointed.
Right. All right.